I want to get into this, a story that I'm writing today. It'll be published on our site by day's end. And this is the Substitute House Bill 2660. So this bill is meant to deal with all these kids that are dying often in drug addicted homes. And they made it more difficult to remove kids from these homes with the Keeping Families Together Act passed in 2021. Basically said, even if we find open drug use in the home, hardcore drugs included, meth, fentanyl, that isn't necessarily considered imminent harm and as, impetus for removing a child from a home. And as a result, we have had more child deaths and near deaths in the state of Washington for the year 2025 than ever before. So this bill 2660 that was debated in the House Appropriations Committee on Monday authorizes a court to order a parent to comply, but with least restrictive conditions necessary. It says necessary, I'm reading from the bill summary here, to maintain the safety of a child who is under age 5 in the home if the court finds that there is a reasonable cause to believe these conditions are necessary to maintain the safety of the child. The problem, according to opponents, is that the bar is so high for removal of a child to the point that even, as I mentioned, that open air drug use is not often enough to remove a child. And we've had social workers, we've had judges, prosecutors begging lawmakers to fix this so that we can save kids' lives. So the contention here from opponents, including Representative Travis Couture, is that we're not going nearly far enough. In fact, as he put it, this bill is about putting lipstick on a pig. So he, again, as I mentioned, he offered several amendments fixing the harms of this act and urged lawmakers to please change the imminent harm language to prioritize child safety ahead of these, drug addicted parents. So here's part of what he said in Monday's emotional testimony in that hearing.
They did not have an ability to remove that child because of the imminent physical harm standard in the Keeping Families Together Act. And it's very important to know that words matter. And when you use the word imminent, that is a measure of time. And what this amendment would do is change in the shelter care hearing process that the standard at which the court determines whether to remove a child from the child's home to require that the court remove the child when necessary to prevent substantial risk of serious harm instead of imminent physical harm in the current law, and also adds that this harm may be due to caregiver incapacity and substance impairment, among other things. It's absolutely important. If you're on fentanyl, you cannot care for, clothe, bathe, feed, shelter yourself. How can you do that for a child? You can't do it for a child, and that's why we've seen an incredible rise in critical incidents, including child death, as a result, especially as it relates to fentanyl. And we've created a system that accumulates risk as the state acts in its own negligent way, standing by as kids who are subject to abuse and neglect get left behind in homes where parents are abusing hard drugs like fentanyl. And that risk escalates, and social workers with high caseloads, sometimes up to 30, 40 amounts of caseloads under their belt, have to try to pause everything and go down this entire list of incredibly impossible tasks just to get into the shelter care hearing to be told, no, we can't remove this kid because we can't prove the word imminent, that it was going to happen tomorrow. No one has a crystal ball. No one has a crystal ball to tell the exact moment on the clock a child is going to die, but we just use our common sense under this amendment and know that it's reasonably possible for that child to be harmed or killed as a result of leaving them in their homes to die.
So all but one of the amendments offered by Representative Travis Couture, who I should have said is a Republican from Allen, were rejected. Only one was accepted, and it passed out of the House Appropriations Committee and was sent to the Rules Committee, and that means at any point it can be pulled to the House floor for a full vote. I'm told to expect a lot more passionate debate on the House floor on that measure.